There's a moment in every long-running crisis when the story stops being, can he get out of this? And becomes, how fast does this unwind? Not because the person at the center suddenly changes, but because the system around them begins moving in a way that can't be paused with slogans, motions, or bravado. Imagine a late night in the Oval Office. The building is quiet. The staff has thinned out. And the president is sitting alone with a briefing packet delivered by counsel, one of those documents that doesn't try to reassure, doesn't use euphemisms, and doesn't pretend the odds are negotiable. The conclusion is blunt. The situation has crossed a point where normal escape routes no longer function. Not because of one catastrophic event, but because multiple failures are compounding at the same time. Call it a point of no return. Call it a cascade. Call it a convergence. The label doesn't matter. The mechanics do. Most legal problems, even serious ones, have off-ramps. You can settle civil cases. You can bond judgments to buy time on appeal. You can reorganize finances in bankruptcy. You can negotiate plea agreements. You can stabilize the narrative enough to keep allies from bolting. But those mechanisms only work if a few conditions remain true. You need liquidity, or at least collateral that lenders and bonding companies accept. You need a stable legal team capable of running complex cases without constant turnover. You need credibility, enough that courts and prosecutors believe your filings and disclosures. You need time. And crucially, you need discipline, the ability to pick battles, make concessions, and stop generating new problems faster than the old ones can be managed. In this scenario, the unstoppable phase begins when those conditions fail together in a short window, and each failure amplifies the next. The first failure is the bond problem. Appeal bonds are the overlooked hinge of high-dollar litigation. If you lose a case and want to appeal, a bond is what protects you from immediate collection. It's not a perk. It's the price of staying enforcement while you ask an appellate court to review. No bond, no pause. The creditor can execute. When defendants can bond, they keep operating. When they can't, every judgment becomes an immediate asset drain. Accounts get restrained, liens get recorded, cash flow gets redirected. In the real world, this is what turns "we're appealing" into "we're being collected against." And once collection begins, it becomes harder to bond the next judgment because the collateral base shrinks. Less collateral means less capacity. Less capacity means more enforcement. More enforcement means less collateral. The loop tightens. The second failure is legal infrastructure. High-stakes cases are not won by one great courtroom moment. They're won by continuity, detail, and institutional knowledge. Lawyers need time to learn the file, identify weaknesses, build strategy, and anticipate moves. When lawyers cycle out rapidly because of unpaid fees, ethical concerns, internal conflict, or fear of reputational harm, the defense quality drops. And it doesn't drop gently. It drops sharply. Inexperienced counsel miss deadlines, file weaker motions, fail to preserve issues for appeal, lose credibility with judges, make tactical errors that a seasoned team wouldn't. And each loss produces new orders, new sanctions, and new exposure. That creates another feedback loop. Weaker defense leads to worse outcomes. Worse outcomes increase financial pressure. Financial pressure triggers more departures, which makes the defense weaker again. The third failure is self-inflicted criminal exposure. In a desperate phase, powerful defendants often try to solve legal problems with political power, public threats, pressure campaigns, and sometimes attempts to interfere with processes that are designed to be independent. When that behavior crosses into interference, prosecutors stop viewing the case as just old conduct. It becomes current conduct. And current conduct is often easier to charge. Obstruction, witness intimidation, contempt, misuse of authority. These are crimes that can't be settled away with money and can't be avoided by pointing to ancient timelines. They create fresh liability and they harden prosecutors' posture. Once prosecutors believe a defendant is actively trying to derail the system, they become less interested in bargains and more interested in deterrence. They move from resolve to send a message. And that shift matters because it changes how the whole system treats the defendant. The fourth failure is the loss of institutional backstops. Powerful defendants often assume some institution will intervene at the last moment. A higher court, a friendly judge, a political protector. Sometimes that happens. Often it doesn't. And when it doesn't, when emergency applications are denied quickly, when higher courts refuse to pause enforcement, the signal is loud even if the order is short. You're not getting rescued. That signal changes behavior in lower courts. Judges who were cautious about aggressive enforcement become less cautious. They stop granting extensions. They stop entertaining repetitive motions. They stop acting as if the defendant deserves extra patience. The case starts moving on rails. The fifth failure is political insulation evaporating. For a public figure, legal problems aren't just legal. They are political. And political support functions as a form of oxygen. It shapes how allies behave, how donors calculate, how party leadership frames risk, how surrogates defend, and whether institutions feel pressured. When political allies begin distancing, quietly at first, then openly, the defendant's posture changes. Prosecutors and judges become less concerned about backlash. Donors stop funding endless defense. Staff begin preparing exits. The base may stay loud, but the machinery of support thins. And thinning support increases the perception that the outcome is inevitable, which causes further distancing. Another feedback loop. The sixth failure is international recalibration. This is not about foreign governments choosing sides in a domestic legal fight. It's about risk management. When leaders abroad perceive that a U.S. administration is unstable or distracted, they hedge. They delay major agreements. They reduce reliance. They shift to contingency planning. Adversaries probe. Allies seek clarity through alternative channels. Even if no one says it publicly, the behavior changes. And that behavior can weaken the administration further because fewer foreign wins means fewer success stories, which means less political strength at home. The seventh failure is psychological. This is the one nobody wants to talk about because it sounds personal. But in high-pressure systems, it's operational. Some leaders can shift strategy under stress, triage, compromise, choose battles. Others can't. They escalate. They fight everything. They refuse any concession. They treat every loss as betrayal and every restraint as persecution. That personality profile is disastrous in a multi-front legal crisis because optimal strategy requires selectivity. Settle some. Focus resources on existential threats, stop generating new exposure, and preserve credibility. When a leader is incapable of that kind of strategic retreat, they burn resources everywhere. They turn manageable problems into unsolvable ones by refusing to prioritize. So how does the point of no return show up mathematically? It shows up in cash flow. Legal defense is expensive. Judgments trigger enforcement. Enforcement reduces liquidity. Reduced liquidity makes defense worse. Worse defense creates more judgments and more enforcement. At some point, the monthly outflow exceeds any plausible inflow, and the timeline becomes predictable. You don't need to know exact numbers to understand the pattern. If you're losing assets faster than you can replace them, and you can't bond judgments to pause collection, the system will keep stripping value until there's nothing left to strip. And if criminal exposure is rising at the same time, you can't buy your way out. You can't settle a prosecution in the way you can settle a civil case. You either win at trial, negotiate a plea, or lose. And trials require money, talent, and time. Exactly what the cascade destroys. That is why, in this scenario, the legal analysis reads like a systems failure report rather than a legal memo. It isn't saying, this is hard. It's saying, the mechanisms that normally create breathing room are gone. Once that's true, the next questions are not about escape. They're about timing and collateral damage. How fast do judgments get executed? How quickly do receiverships and restraints expand? How soon do criminal cases move from investigation to indictment? How much governmental attention gets consumed by personal defense? How much institutional strain accumulates before a constitutional remedy is considered? And in a presidency, that last question becomes unavoidable, not as a threat, but as a reality. If the leader is spending most of their time fighting personal survival, governance suffers. And when governance suffers, pressure grows for extraordinary remedies, resignation, removal, or incapacity mechanisms. This is why people call it unstoppable. Not because the law is vengeful, but because the law is mechanical. It doesn't care about mythology. It cares about deadlines, orders, enforcement tools, and evidence. In the end, the point of no return isn't a single dramatic photo. It's the moment the system stops responding to pressure and starts responding to procedure. When every motion is met with denied, every delay is met with deadline, and every claim of exception is met with the rules apply. That is what a cascade looks like when it reaches full speed. And once it's moving that way, the only question left is how much breaks on the way down.